Good evening and welcome back. You're watching Newsbreak. I'm Rishika Barwa. In a landmark order, the Karnataka High Court has allowed the framing of charges against a husband in a case of marital rape. Marital rape, remember, is not yet a criminal offence in India despite years of a campaign against it. The Karnataka High Court today, in this very landmark case, has actually noted that the institution of marriage doesn't confer any special male privilege or license for unleashing of a brutal beast. They've also further clarified that a brutal act of sexual assault on a wife against her consent by a husband can be a rape. Let's go right across to Arvind Gunasekar, who's tracking the details of this story. Arvind, you've read this order in detail. Can you break it down for us?
Rishika, the Karnataka High Court in a landmark judgment has allowed the husband to be tried for rape. This is a landmark judgment in the context of the marital rape, though the exemption given under the rape law, that is under section IPC 375, that is being adjudicated by the Delhi High Court. But the Karnataka High Court, going into the facts of a case that was before them, has actually allowed framing of charges, the rape charges against the husband based on the complaint of the wife. The wife had filed an FIR against the husband for alleging rape, and that the Karnataka police, after a detailed investigation, has also filed a charge sheet in this particular case. But the husband had moved the Karnataka High Court challenging the framing of charges under section 376, that is the punishment for rape, saying that the section 375 gives exemption for the husbands. But the Karnataka High Court, going into the facts of the case, has allowed the husband to be tried for rape under section IPC of 376 based on the complaint of the wife. Like you mentioned, while allowing this particular husband to be tried under rape law, the High Court has also made in the context of the marital rape, wherein the High Court has said that institution of marriage does not confer any special male privilege or license for unleashing of a brutal beast. The High Court has also gone on to say that a brutal act of sexual assault on the wife against her consent, albeit by the husband, cannot but be termed to be a rape. So the High Court has made it very clear the husband in this particular case cannot seek exemption or the protection under section IPC of 375, but whereas he has to be tried for rape. So that's a very important judgment that has been given by the Karnataka High Court, and the Karnataka High Court has also said that we have not gone into this exemption given under the husbands overall. That is for the legislature to ponder over this, but based on this particular facts of the case, we are allowing the trial court to proceed by framing of charges, that rape charges against the husband in this particular case.
Very important that the court there is allowed for framing of charges in this case. Of course, whether or not finally he's convicted or not, that's a secondary issue. But the fact that the court has allowed for framing of charges in a case of marital or alleged marital rape in itself, is extremely, extremely important, given the fact that marital rape in India is not a criminal offence under the IPC. Thanks, Arvind, for joining us with the very latest. Let's also get in a perspective from Ashwini Dubey, advocate of the Supreme Court, as well as Ranjana Kumari, Director, Centre for Social Research and the Chairperson of Women Power Connect, also social activist. Thank you both very much for being with us. Ranjana Kumari, to you first. This is indeed being looked at as a landmark verdict by the Karnataka High Court. It'll have far-reaching consequences.
Yes, sure, because this discussion has been on since Verma Commission, and all the women's groups recommended to Verma Commission that marital rape should be made a criminal offence, and but then it was included in the recommendation. However, the Parliament did not accept that, and that exemption that was exempted, and also exception was made. But I'm very, very happy and welcoming this Karnataka High Court's observation, and in the case of marital rape, because one thing that they have challenged is old traditional thinking that husband becomes the malik of the the owner of the woman's body and her life and future, and makes every decision about her, and she doesn't have any agency, any autonomy, anything in after marriage. So, and also secondly, the observation that marriage does not give a man license to rape. That happens outside the marriage, then it is considered offense, a criminal offense. Then how can it be acceptable when it happens within the marriage? So that's a very major observation, and I feel it's time that Parliament should start looking at these issues and also start immediately, because there is a lot of discussion about it going on.
Yes.
We need to legislate it. We need to legislate to strengthen the hands of judiciary to be able to give justice to women. Otherwise, it is just going on, and so many women within marriage are suffering brutality at the hands of their husband.
Not just as the Karnataka High Court allowed for framing of charges in an alleged case of marital rape, but Ashwini Dubey, the court interestingly has also noted, and I quote here from that order, that the institution of marriage doesn't confer any special male privilege or license for unleashing of a brutal beast.
Yes, Rishika, there are two aspects. One, if we see, as said by Ranjana ji, the Justice Verma Committee report, the Justice Verma Committee has categorically recommended for deletion of the exceptional clause, that is 375 to exception, which this give liberty to the husband and not to be tried under the offense of the rape. But if we look into the various aspects, various judicial precedents and various international laws, like the law from Australian states, New Zealand, Canada, Israel, France, Sweden, Denmark, then we find that there is a marital rape which is punishable under the law.
Yes.
So 375 to exception. For that, the debate as well as the hearing is going on so many days, at least 2 to 3 weeks. Honorable Delhi High Court heard that matter, and finally that matter is still pending before the Honorable High Court. They're looking into it. What should have been the approach of the legislature? Legislature must have taken the various aspects which was considered by the Justice Verma Committee report when Nirbhaya case happened. Also Article 14 of the Constitution of India, Article 15 of the Constitution of India, Article 21 of the Constitution of India. Because only defense or only argument which is being made that it will destroy the institution of marriage. But Justice Verma Committee has largely dealt with that issue, that it is not only the aspect which will destroy the institution of the marriage. There is a consent, there is a no consent. If it is defined in the law, then why there is a difference between man and the sexual assault versus sexual assault? So I think that today's judgment of Karnataka High Court, because as a student of law, what I understand, that as a judgment of this Honorable High Court, which was given though in a private case, but it has a far-reaching impact.
Yes.
Because the Constitution is the fountainhead of all statutes.
Ranjana Kumari, where does, while of course, we're welcoming what the Karnataka High Court has said, and we will also, go back to Ashwini Dubey to sort of explain what next. I want to understand from you, as a social activist, as someone who's worked in this space, what have been some of the biggest hurdles in ensuring that the legislature actually looks at marital rape as a law?
Well, you see, I consider that no man in marriage wants to be and is a rapist. I don't want to say that and brush them all with same paint that they all are rapists and they are brutalizing their women in the marriage. But there are men who are doing it. We do receive cases where women have come and complained to us about, the brutal act in sex, and because men consider that as their right over women's body and sexuality. That's the most important thing in marriage, that is not being clarified, that women have their own desires and their own consent about what is happening to their body.
No, but why hasn't this happened all this while? Where does the buck have to stop?
Yeah, let me give you a very small example. After Verma Commission's recommendation, we had met members of parliament to accept this and to remove the exception. But senior members of parliament, I remember the discourse at that time, said that, do you want to bring police in the bedroom? Do you want state to interfere in marriage relations? Do you want marriage to survive, or you don't want marriages to survive? I think when marriages are living under a condition of rape, then better not survive. Such marriages better not survive. And we can do away with such institution of marriage. But I believe that marriage of institution is fundamental to Indian society, and we do need to clean it and cleanse it of this kind of a sexual assault and sexual, a brutal sexual act, as court itself has recognized. that this has to be weaned away, and that can only be done by really legislating and sexual assault and rape in marriage.
Where do we go next? Ashwini Dubey, given the fact that there is this landmark judgment of the Karnataka High Court that a man can be tried in a case of marital rape, charges can be framed against him. A series of very important things have been said in this judgment. We're putting out those excerpts on our screen. What next?
See, Rishika, one thing is clear that the judgment does not have that it will be having impact all over, and that has to be on the state of Karnataka. Judgment says now it is the legislature's duty to take a call. But what I think that it is against the basic tenets of the Constitution of India and against the basic object of the Constitution of India, Article 14, 15 and 21, because you cannot differentiate rape and rape. So what I understand that this law was enacted in 1860 when this exception came into picture. But the Britishers who enacted this law, they themselves have abolished this clause. So it was the British colonial rule which is still existing in the country, and I think
so you're saying that what the Karnataka High Court has noted today will not have any impact, so to speak, on similar cases until and unless this is actually formalized by the legislature and a law is passed.
Rishika, with little correction, it will be having impact, but that will not be cited as a precedent or law, because Honorable Judge has also gone in saying that if husband is not guilty, he may prove himself innocent during the trial.
Well, absolutely, and like we said, it's not like the husband in this case has been found guilty as well. Just framing of charges has been allowed. So a case will be fought on the merit. Ranjana Kumari, you wanted to come in.
No, I just wanted to say that court's observation that is archaic, it is regressive, it is, preconceived notion that women are, and also cases are mushrooming in the country. It's court's observation. We have been saying it, but now court is also saying that such cases are mushrooming in the country. Now, in this situation, don't we want to save our women from this brutality? Don't we? So I think following these kind of judgments and observations, it is important for our legislature, especially our parliament, which is sitting at the moment in function, so they can bring in this issue. And I will appeal to women legislators, members of parliament, to really draw attention of the parliament, who private member bill or whichever way they want to do, push the government to legislate this, because this has been going on since Verma Commission's report was submitted, and it's been a long story now. We need to really protect women.
Very last clarification, Ashwini Dubey, does this impact the ongoing case?
See, this Honorable Court has already heard the matter at length, and the Government of India's point of view has come. But the thing is, yes, no doubt, it's a judicial order. Judicial order has an impact. But only thing is that unless and until there is a law which is enacted, this will not be having any impact over the cases which are to be tried in future.
Okay. Well, thank you both very much for joining us. Indeed, like I said, a landmark order. Where it goes from here is a story we'll continue to track very closely. Thank you again.